Hello, my name is Jamie Hunter. I'm actually the managing attorney at Elizabeth Hunter Law Firm, which is a criminal defense as well as a civil rights and a personal injury law firm. So I wanted to just talk to you all briefly about Miranda warnings. With me being a private attorney, I get a lot of misconceptions about what are they, when they apply, and how they apply. They look on TV such as Law and Order and CSI, and they assume it would happen in the real world, but that's not the case at all. So I wanted to just talk to you about it and just give you an idea on what it really is and how complex it actually can be as to whether or not it does violate your Fifth Amendment right. And that only applies, or it takes into effect, when you are being arrested, of course. So for one, you have to be in custody. For two, police have to actually question you, not you volunteering statements on your own. And then for three, those questions have to amount to some sort of interrogation where they at some point believe they would elicit a incriminating response from you. First thing that I want to talk to you about is custody, of course, because there's some confusion there. A lot of people think that just because police officers are handcuffing them, that they are under arrest, when that's not the case at all. In some jurisdictions, there are a distinction between an arrest and detention. Officers oftentimes will detain you, and they will actually tell you that they're detaining you to investigate further. For instance, DUI cases, officers will pull you over. They may not arrest you, but they may detain you to investigate further. For another example, there's domestic violence calls. So police officers, they have a duty to investigate. When they're called to a particular place or residence, whatever it is, they have a duty to talk to each individual party. And while they're doing that, that's called police investigation. It's not interrogation. It's to basically, in their mind, come up with some sort of analysis as to who the aggressor is. And at that point, they arrest that person. And then that's where that custody starts to come into play. And just be mindful of what custody is. It's not black and white. It's basically the totality of the circumstances. Us lawyers love to say that because it just sounds so lawyer-like. But the point is, everything plays into a factor. How long it happened, where are you, what's happening. The point is, it's from a reasonable person's mindset. Under those circumstances, you felt you could not leave. That's where another prong comes into play, where there is some confusion about what police interrogation is. It's not just questioning. It's more about what the officer is trying to elicit out of you. I'm going to give you an example. So for instance, you're taken to the police station and they start asking you questions. And at some point they stop asking you questions and you just randomly blurt out, "I shot him." That statement actually is admissible. The only reason why is because it's not in furtherance of the police officer trying to elicit a incriminating response. And I know that sounds a bit confusing, but if you think about it, if the officer's not asking you questions, especially if the response is not purported to his question, you just randomly just blurt out something, that actually is admissible, and it's an admission by you voluntarily, and it actually can be used in court. However, if we're talking about a police officer actually asking you questions and he believes in his own mind that it will elicit a incriminating response, then at that point it would become admissible if at that point he has not given you your Miranda warning. So just to sum it up, just be mindful that Miranda warnings as well as potential violations, it's a lot of gray area. You have to basically find the right attorney to figure out if there is a violation and where it occurred. Okay, so for one, you need police custody, you need police questioning, and whether or not that questioning amounts to police interrogation. So just be mindful when you're making these statements. Are you making these statements because an officer asked you a question, or are you just making them because you want to just voluntarily give information? And often police officers conduct these psychological tactics where they don't even have to do anything and they'll elicit some sort of response. So for example, you may be in a room with a bright light and you may have been in there for hours with no food, no water, you're tired, it's 4 a.m, and the officer who just got on his shift came in and starts asking you questions. He's okay. You're tired, you're barely making it. And you start to say certain things that are incriminating. But at the same time, those would be, at least courts consider, involuntary statements, because at that point you feel forced to say something, for one, to go home, and if for two, you think that's the only way that you can go home. I see this all the time with false confessions. And oftentimes the police officers didn't even have to do anything, or the investigators didn't have to do anything, simply because they just tired you out. And most importantly, if you do happen to get arrested and you are in police custody and the police start to question you and those questions amount to interrogation, make sure that you say nothing other than a request for a lawyer.